This is case D10-434-927D. Counsel, your appearances, please.
Nikki Dupree O'Brien, bar 11111, on behalf of Shanna Soares, who is present.
What was that number again?
11111.
Amanda Roberts, bar number 9294, on behalf of the defendant who's present in the courtroom, bar number 9294.
Remind me of Dealey never to play bar number poker with her. Five of a kind.
I think
Oh, you
I'll
want Carol
win.
Menninger's
Ridiculous.
number, like 25? Who's 25?
Fran.
Oh, okay.
Yeah.
I thought it was 25.
Same difference
Yeah, right.
on most days. All right. Ms. Roberts, is there anything that needs to be brought to the court's attention that is not in the pleadings?
The only thing we would tell you, Your Honor, is that my client would be willing to front the cost for a brief focus assessment to address these issues. He's very concerned about what's been going on, the violations of the legal custody and things that we believe warrant the modification and increased time. So if the court is so inclined, we would be willing to front the cost for that. The court can focus the issues, which will limit the cost. And we were just
So
talking.
what are we going to limit it to? What's the assessment going to be based on?
The factors under 125-480. The only other factor that would be relevant would be.
Well, I mean, that's basically everything. What are we?
You want the specific preferences?
Yeah. What
Okay.
do you want to limit the assessment to?
Okay, let me grab it. We want to look at fostering and encouraging the relationship, the conflict between them, the ability to cooperate to meet the kid's needs, the physical, developmental, and emotional needs of the children, and the relationship between the parents and the children.
Okay.
The things that we argued in the motion.
An assessment might get us somewhere there, but it sounds like some of that, or the bulk of it, could be resolved with a parenting coordinator, right?
I mean, I don't know, because if the court just leaves the timeshare as it is and you appoint a parenting coordinator, I don't know that that's sufficient, because we believe that what is going to ferret out is that mom is engaging in a pattern of alienation. She is trying to cut him out of the children's lives, and it's
Okay.
the
All right.
timeshare is
Anything else, counsel?
contributing to that. No, Your Honor. Oh, I brought the passports and the applications and all that stuff.
All right, Ms. Dupree, anything that's not included in your pleadings that
And-
needs to be brought to the court's
Yes, Your
attention?
Honor. I just got their reply in opposition on Monday, and it was e-served on Monday to me. Just a couple of issues, just the child and spousal support arrears. There's just a few of the checks, if we can see front and back. My client always deposited them, and we don't have front and backs on all of them. So there's just 3 that we still have an issue with, and I can work that out with Ms. Roberts, I think.
Okay.
And get
Yeah,
that.
if you tell me the numbers, we'll give you the proof.
All right.
I don't know if we want that on the record. The other thing, they bring up this parental alienation. He's been doing a pretty good job
Right.
himself.
Okay.
The
Any-
surrogacy, and I just, Your Honor, I just want it, because they're making allegations that my client's grilling these children, and that is certainly not happening.
Okay.
If Your Honor would meet Mark, he's a very vocal little boy, and every time I see him, I know them personally, he starts talking. You don't even
Right.
have to ask him questions. The surrogacy was never mentioned. Shannon, in fact, talked to his, I guess, wife, that he's now married. That was never brought to the boys. These are co-parenting issues that goes both ways, and while it's none of Shanna's business, she doesn't care if defendant gets married, it'd be nice to know, because the boys, you can actually co-parent and discuss things with the boys together. Even the surrogacy, that's a big
Well,
thing for little boys to have to
Okay,
deal with.
look, let's cover some ground here then. So what is Dad's current visitation schedule, Ms. Roberts?
Current visitation provides him with. Sorry, Your Honor. Wednesdays from 6 to 7:30. And the first weekend of each month, Friday at 5:30 until Sunday at 5:30. And then the second, third, and fifth weekend, Friday at 6 until Saturday at 8. They haven't been always exercising the Wednesday because they were trying to accommodate the boys' schedule. So what they did is extended, kind of like on a de facto, a timeshare, extended the weekend so that they could participate in some activities.
Got it. And so as for the telephonic contact issue, the telephonic contact needs to take place nightly. If it doesn't work from 4 to 5, then a text message should be sent from whoever has the kids regarding the delay, and should take place at the most as soon thereafter as is possible. Dad's request to modify physical custody is denied. The court finds that there's no adequate change in circumstances at this point in time to support a modification of physical custody. The request to modify the holiday schedule, I'm not sure what their holiday schedule is, but I will ask my marshal to provide you with copies of my holiday schedule, and the court will encourage the attorneys to make modifications as necessary. Otherwise, that schedule will be adopted. The court will allow the children to obtain a U.S. passport. The court will admonish Dad that if he attempts to obtain Brazilian passports for the children, the court will immediately suspend any visitation and contact that he has with the children. Any attempt to obtain passports or citizenship papers from a foreign country would be viewed as an attempt to abscond and alienate the children. You understand that, sir?
Yes, sir.
You can obtain a U.S. passport, but no way, no how should you make any effort to obtain a Brazilian passport or any type of citizenship document evidencing they have dual citizenship.
Mark already has that. He's had it since they were married.
Dual citizenship
Yeah, sure.
documents?
Yes, Your Honor.
Shanna does not believe he has that, Your Honor.
He's always had it. He's had it since they were
Where
married.
are the documents?
My client has them.
That's
All right. Well, those documents need to be delivered to the plaintiff. The plaintiff will maintain those documents, will release them at her sole discretion at this point in time. Shanna is going to be ordered to attend and complete the cooperative parenting class from UNLV.
Your Honor, can we make that for both? Oh, he already.
He's already done it.
He's done it. Okay.
The court is going to admonish both parties that you need to try and limit your children's involvement in your adult issues and in the divorce issues. The request from Dad that Mom provide him with health care provider numbers, daycare, all of this information seems to be a little bit overreaching. He should have access to all of that documentation. Once she has provided him with the name and contact phone number for healthcare provider, dentist, daycare, then she would only be required to update if there is a change. He can obtain records on his own. As for the school, she will, unless the children are changing school, he has the same access to the Clark County School District as she does.
She has them in a different school, Your Honor. They're not old enough to attend Clark County yet, so we don't know the name of the school she has them in.
Well, then they're not in school. Wait,
Your Honor, if I may, he went up there for Mark's birthday and I believe brought cupcakes or saw him in class. He knows where Mark's been going to school. Matthew
He was the one that we
just
don't.
turned 5 and the parties need to discuss kindergarten for Matthew.
where's Mark attending next year?
Doral Academy. It's over off of Cactus and Mountain Edge Parkway.
That's a charter school?
It's a charter school. And he's been going there now for two.
And is there a reason that he's not attending the Clark County Public School?
No specific reason, Your Honor. It's a good school. It got
Mr. Roberts, does your client have a problem with him continuing to attend Doral
No,
Academy?
Your Honor.
All right, so Mark will remain in Doral Academy. We would anticipate that Matthew would attend the same school when he reaches school age. He's not old enough to attend school yet?
kindergarten. Well, yeah, and I don't know, we haven't discussed with defendant if he's got any objections. I know Mark started in kindergarten, it's not mandatory in Nevada, so,
Well, look,
but we'll talk about it. If defendant does not have a problem, Matthew will be attending Durrell as well.
this fall.
Yes.
Okay, all right. So we'll just anticipate that he'll enroll in kindergarten in the fall this year at Doral. But Dad is on the school records and should have all the same access to computer monitoring, email for the teachers, etc. I don't believe it's necessary or incumbent upon mom to provide documentation to him. What she does need to provide documentation of, regardless of whether it has anything to do with his time or his contact, is notify him of any and all extracurricular activities that the children are enrolled in and provide a schedule of practices and performances. I don't anticipate that Dad should attend practices if it's not his time, but certainly games and performances he should be encouraged to attend and participate. Further, Mom, it's anticipated that she will have more close contact with the school, and she will be emptying out the backpacks at the end of each day. Should provide calendaring notices for Dad of any activities, special events that the school is hosting, which the parents may be encouraged or invited to attend. Do you understand that, ma'am?
We understand. And Your Honor, if we can just put on the record, Dorel does everything online, so if we can just make sure Dad does make sure his name's included, so he does get those online announcements as well.
Okay, but still, any scrap of paper that comes home, I'm not gonna rely on Doral to post everything online. The request to hold Mom in contempt is denied. The request for fees and costs is denied. Ma'am, your children are not old enough to be involved in communications regarding this divorce action, child support, or any other dispute between you and your husband. Do you understand that? I don't care how free and open you wish to make your communication. As long as I'm involved in your case, you're not going to talk to the kids about that. I don't care how many questions they have. I don't care how many times they ask you. If you volunteer information or expose them to the litigation issues or allow them to review court documents, I will hold you in contempt, and I will sentence you to 25 days in the Clark County Detention Center. Am I perfectly clear? Do you have any questions regarding that order? As I've stated, even if you enroll the kids in some activity that has no bearing upon Dad's timeshare, you're required to inform him of that activity, as well as the schedule, and especially for performances, belt tests, etc. If you're showing up to every practice and making yourself a nuisance, that's going to be a problem. If you show up to special events, that's a good thing. What's Dad's timeline for his trip to Brazil?
It would be next year, Your Honor. It's too late in this year to get the plane tickets.
And although Brazil is a Hague signatory, there has been a history of problems in retrieving children from Brazil. And so, counsel, before your client wishes to go, he needs to provide sufficient advance notice that if Mom doesn't sign off on it, that he can file his motion, and he needs to be aware that this court would likely require him to post a significant bond in order to travel.
Can you just give me an amount, Your Honor, so that he can do the research on it?
He'll have to file a FDF, and I'll determine at that point in time. I don't know. I can't tell you how much.
Okay.
We would be looking at something in the $40,000 to $50,000 range if I'm just going off the top of my head, but it could be significantly less depending on his assets. All right, now Mom's request. She requested I deny the request to enforce the custodial order. I don't get that, so we'll just skip it. Why does she want a child interview, and what on earth would I be asking these children?
The child interview, Your Honor, was if we were moving forward with any kind of a custody change. I don't think it's necessary. It would give Your Honor some idea what the boys see and deal with on a
As for
daily
his
basis,
request to
but
obtain a U.S. passport for the children, that request is granted. He's allowed to obtain the passports. If he does so at his sole expense, he will keep the passports in his possession. Passports would be available to be used by either parent upon advance notice and providing a complete itinerary for the international travel. I'm not foreclosing the issue of travel for Brazil, but once again, counsel, I would need to have a clearer picture of what the financial status is, and the court would likely require some kind of a bond.
I'll talk to him about it.
There have been significant issues with Brazil and their enforcement of foreign orders, which is also part of the reason that I don't want any document. And I mean, if there is a dual citizenship already for Mark,
He also had a passport that expired. That's why we wanted the other passport.
yeah.
Either way, she's gonna have to sign off for him to be able to get a visa to go with the kids.
I got that, but I'm just saying I have concerns because that seems to have been part of the problem with compliance with Hague.
I thought you were
is
talking
this
about him.
No, not
Okay.
him. I'm talking about dual citizenship creating.
So if he turns the documents over to me and I hold on to them, provide proof, is that sufficient? I don't want mom to have them either because she could do the same thing.
I'll hold on to
Gonna
them.
disappear to Brazil?
Maybe. I mean, what does it hurt if I have them?
It doesn't. If you want to maintain those documents, then go right ahead. But once you have them in your possession, provide proof and an affidavit to the court that they're in your custody and will remain in your custody until further order of this court.
Honestly, Your Honor, I've been an attorney of record on this case since they got divorced in 2011. We've been on it since 2010, so.
Okay, I've ordered her to attend the co-parenting class because it seems that she is perhaps a little bit too open and free with information that these children wish to access. I'm not sure if that's the appropriate class, but I'm going to issue my admonishment, and it's going to go both ways. Okay, you guys are the parents of these two kids. That means you guys can do anything you want as long as you're in agreement. If not, I get to make the decisions. My parenting decisions may be vastly different than yours, but kids are kids. They're not to be given any authority to make decisions regarding custody, visitation, or any other issue between the two of you. You're the parents. I hereby order you to be parents and make those decisions between yourselves. And if you can't reach those agreements, then you come to court and I'll make the decisions for you. Your kids don't get to pick and choose. Your kids don't know anything about child support. They don't know anything about visitation. They don't know anything other than what their schedule is. You tell them what to do, when to do it, and how to do it, and then you deal with the backlash as parents. We're not going to provide them information and allow them to form their own opinions, not even when they're 16 or 17. When they're 18, then I don't have any control over them anymore, and you guys can do whatever the heck you want. But the most tragic circumstances I see in this courtroom is when parents have told children that it's their decision. And I'm not saying that's what you're doing. But you're getting, I'm reading things in here that are raising the red flags in my mind. And I don't know that you're doing much better because there seems to be a lot of information flowing to you from these children. The testimony, the statement I've heard from your attorney is you got a kid who likes to talk, and I don't have a problem with that. It sounds like the kid likes to tell stories a little bit too. If you guys are not the first call you make when the child starts talking, and you guys don't have confidence and some degree of trust between the two of you, then little Mark is going to cost you an arm and a leg in litigation fees. And by the time he's 14, 15, and 16, he's going to be ruining both of your lives. Potentially your relationship with your current wife. Because he's going to figure out exactly what it takes to manipulate both of you into doing what he wants or what he thinks he wants, which is the reason we don't let kids make those decisions, because what they think they want isn't what's best for them. We don't give them cake and candy for breakfast, all right? Well, maybe I do on occasion. But look, folks, you're parents. You're divorced. There's problems between you, go to that class. That is like he said, it is a good class. And then, for heaven's sakes, you guys got to communicate with each other first. You have to realize that your kids might not be telling you what you need to hear. They might be telling you what they think you want to hear. And that kid doesn't know what's right for you. The kid just is doing whatever the hell he thinks you want him to say. He should be in some kind of, and I don't know if it's both of them together, but there should be some kind of therapeutic involvement. Now, if you're not going to participate, then pick a counselor, and you'll make the child available even during times that are not dad's times for that therapeutic involvement. I think all of you should be involved in that. I think certainly at a minimum, Mark should have somebody who's a therapist that he's able to talk to from time to time. And maybe the first step you take after you talk to each other when he tells you something unsavory or weird is you take him to the therapist and you let the therapist talk to him for a while about it and figure out what's going on. All right? I'm not judging your child. I don't know your child. Okay? I'm just telling you, I sit here and I hear these things a lot. And more often than not, the parents in your situation are getting played. Okay? It's not always the case, but it happens enough that I think it would be unfair for me to just start sending you out for evaluations and such if the parties agree to an assessment. Then I don't have any problem signing a referral. You might actually get insurance to pay for something if you seek therapeutic involvement for your minor child. Okay, he's having some issues with the divorce. He's had some issues at school or talking to people at school. He's telling you different things. The minute I sign an order, insurance isn't going to touch it. Okay, you guys as parents, take him to the appropriate person. And once again, I mean, I don't care if the kid doesn't want to do it. I mean, when they're real little and you took them swimming, you made them wear the floaties, you made them wear the life vest, right? I mean, even though the kid tells you no, he doesn't want to be strapped into the car seat, just strap him in. You have to, I mean, sometimes you just got to say no to kids, especially when we're talking about their welfare. And I can't imagine, like I say, I don't know all that's going on with that dynamics, but I can't imagine you wouldn't want the kid to get into some kind of therapy. I understand that in litigation, everything seems like it's an attack and everything seems like it's, done with the intent to change custody or to make an appearance in litigation. But I'm not ordering it. I would be disappointed if you didn't take the child to see somebody and that the whole family wasn't involved. Like I said, I'm inclined to order it, but I think maybe between attorneys, you guys can, if you feel that there needs to be some additional investigation.
If we can't agree, can we submit an ex parte request to address it without having another motion hearing?
Your Honor, I think
Look,
we don't
here's
have
the
a
deal.
problem with Mark in therapy. We don't have a problem with it. It's a matter of agreeing on a therapist.
Within the next 60 days, get the child in to see a therapist. If before the end of that 60 days from today, you feel like you still need some type of an investigation, then contact Ms. Dupree and send a letter, either a joint letter or each of you send your own letter regarding a limited assessment, and I will issue an order on that.
Okay.
Because I mean, at this point, if we can do a limited assessment at this point in time, if that's what it takes, I don't think it's a custody evaluation at all. I think it's merely we're figuring out why the child's acting the way he does, and if either parent's behavior is encouraging that. And even without overt, I mean, kids are smart. They spend a lot of time watching you guys. And she might not be saying anything about you. And he can still pick up on stuff. All right? She might tell him that you're great and fantastic and everything, but he gets some vibe from you that you don't like her, and he might just spout off and tell you stuff. And I don't know. How am I going to know? How do you guys know if you don't talking to each other? That would be the only reason I would send out for an assessment, is to try and gauge what behaviors are setting this kid off, if it's him, or if it, I mean, it could be one of you's secretly manipulative and has an ulterior motive. I hope that's not the case. But if you can't, if by getting him in to see a counselor or a therapist doesn't do it, in fact, let's go out, I'll give you 90 days. And then if you think you need something, but that's what I would anticipate that the assessment would be for, would to be, more to offer recommendations as to how these parties would address those issues. I mean, if there is, in fact, parental, I don't want to say alienation, but if the child is being influenced by the parents unduly, that would be an issue that the court would have to address with admonishments, potentially sanctions. All right. Okay, so is there anything I failed to address that needs to be, that we need to make an order on?
With the therapist, and I know we can talk, if we can just agree it'll probably be somebody on his provider list to keep
Yeah.
the cost down as low
Yeah,
as
if
possible.
if it gets down to you can't agree on a specific name, then Dad will provide 3 names. Mom will pick one off the list.
Okay.
Okay.
Okay. I guess child support review, we're ripe. It's been 3 years since the last order. And we do need current insurance info on the kids as well. We haven't gotten updated cards recently, so.
Yeah, we just mailed it to them.
Okay. Haven't seen them, so.
All right. So 25% of his reported income is $1932. That would be capped. At 1612.
Are we going effective July 1st? The maximums go up July 1st. They go to 8/19 on July 1st.
19. So it would go to 1638. Mr. Pre, any basis for upward deviation?
The only thing we had was just uniforms and school supplies for Mark and Matthew once he's in school. I know when Mark was in kindergarten, it not being required, Your Honor didn't require him to pay anything towards that if he was in kindergarten, but we would ask for some upward deviation, and then of course, and I don't know what Dad's health insurance is running now, of course, we're gonna expect a downward deviation for health insurance, so.
Right. Okay. Ms. Roberts, any arguments or basis for downward deviation other than the health insurance?
Besides the health insurance, I don't think there are any, no.
And is his health insurance, is it, because let's see, 19, I mean, is it more than $600 a month?
No.
All right, because I apply the insurance deviations before the cap, and so that wouldn't affect that. As for the uniforms and school provisions, the court would require the parties, if they agree, and it appears they're in agreement, to send the kids to Doral Academy to split uniforms. I don't know
Like,
whether,
how many?
well,
That's the issue, I mean.
2
Okay.
each. And what other, I don't know what other fees and costs or expenses there are that are anticipated. It's just uniforms?
Some school supplies, but those are pretty,
Well, school supplies
those are
is,
pretty
I mean,
small.
she's
Hey.
gonna,
That's fine.
Yeah.
When you say to each child or to each parent?
no, 2 for each kid.
2 for each kid, okay.
So,
So each parent will provide one uniform.
Yeah, 1 complete uniform.
travel out of state, we never get notice when she's going. She continues leaving the state. We never get notice as required by the decree. So I'd just like to have that in there. The only other thing was the court's not even gonna modify the visitation to allow him additional time based upon what's going on at this time? I mean, the way that it's scheduled, he doesn't even have a full weekend with them under any of,
On the first
sorry,
weekend,
one
he has
weekend.
Friday through Sunday,
that's it, yes.
and then on the second, third, and first, he's got Friday through Saturday at 8. And why were we doing that Saturday at 8
It was
instead of Sunday?
The church
Church
issue.
issue,
On
right?
Sundays. And then he
And
had Wednesdays, Your Honor, and I'd like to point out, actually, almost since the decree was entered, Dad's foregone Wednesday
Wednesdays
evenings.
was Scouts. Well, let's do this.
That's
Is
not
Wednesday
true.
still the Scouts night? All right,
Well,
so
Thursday? I mean,
does he want Thursday?
we don't know what his work schedule is
Alright,
either,
well-
Your Honor, and he's supposed to provide
Well,
schedules.
his
he never
work
has.
schedule is Monday through Friday from 2 a.m. to 11 a.m. And so on Thursday, we will allow him to, if the kids are in school, he'll pick the kids up from school and have them till 7 p.m. Yeah. And if there's no school, then he can retrieve the children at noon and have them until 7 p.m. And that's on Thursday.
Thursdays.
All right.
And then, just so I'm clear, if this pattern continues, whatever it is, and he continues to have this relationship issue, then I have to bring it back by way of motion.
Look,
I mean,
that's what I'm saying. None of us knows what the issue is.
well, that's why we
Okay,
wanted the
so-
assessment. I understand the court saying therapy, and
All right,
we've tried that,
I've told you, well, it hasn't been
Right.
working.
right?
And I've told you if we don't get something done, then
90 days.
submit the letter, and I
Okay.
will. If you guys can't agree on an assessment, then I'll consider it, and I probably would if he's willing to pay the expenses. I mean, if you want me to order an assessment right now,
We'll try the therapist first, and if 90 days it doesn't
what
work.
I'm
That's
thinking. I mean,
And Your Honor, with the child support, and like I said, we'll work out the couple of issues I think we may have on arrears, and hopefully we can just agree on where we're at. But when I've been before you before, it's usually child support's due on the 1st, not late until the last day of the month.
no, that's
Um,
never.
Okay.
I'm always due on or before the last day of each month.
Because we have had some that they get there after the 1st, and it's just,
The child support's due on or before the last day of each
Okay.
month. And Ms. Roberts, I'll ask you to prepare an order for me. But Mom will attend that UNLV class at her expense.
And then,
and is the wage
sorry.
garnishment still in effect?
Wage garnishment she's never even done anything with it. We're fine with it. She went to the DA. I mean, if she wants it, go do it. We don't care.
All right.
As long as
Right.
they're still in agreement with it. It
Okay.
just makes life easier to.
They're
have
gonna
it.
charge him for the wage garnishment. If they charge him, I'd ask her to reimburse
Well, it's
that.
gonna be they're only allowed to charge him $2
Oh.
a paycheck.
No.
It's like $1 or $2 fee per
Well,
garnishment.
why can't she do it? He's always paid on time. She hasn't proved that he hasn't.
Look, anyway,
Their own schedule shows he was late.
thank you, prepare the
you.
order.
What about the travel?
The out-of-state travel?
That was part of the other order. We have no problem with it, but it's two-way street. He's taken the kids to Utah, he's taken them on a plane. You know, they've flown via plane.
Do they both want notification if somebody's leaving
Yes.
town?
Yes.
All right,
We're
then,
fine with that, too.
then yeah, absolutely. Make sure that it's specifically spelled out in the order. If you're gonna travel across the state line for any length of time, for any purpose, then you have to provide an itinerary. And God forbid you walk more than halfway across that damn bridge out there at the river. Right? Okay, have fun.
And then we're just gonna open a DA action. He'll pay through the DA.
Okay,
That'll be easier for him.
all right.
And then I'll give counsel the passport applications. If she can just 7 days, can I have them back?
Yeah, I mean, you should be able to get them back by Friday, right?
If I can just have them within 7 days,
Okay,
that's fine.
within 7 days. And then make sure that you file something with the court, indicating that you have,
I'll have them bring them to me and I'll file it by Monday.
yeah, and make sure they're original documents and not just copies.
So the passport that's expired, you want me to have that and just,
Is it an expired
Okay, the only thing he
Brazilian
has is-
passport?
yes, but he doesn't have that. We don't know what happened to that. The
Okay.
only thing he has is the dual citizen,
Brazilian birth certificate.
the Brazilian birth certificate.
born in Brazil?
No.
No,
No.
but it's recognized in Brazil. That's why he was able to get the Brazilian passport.
Okay, all right. Yeah, just, I mean, keep it in your files until,
That's fine.
all
I'll put it
right.
in my file.
Brings us more.
Okay, thank you. Good luck, folks.
Thank you, Your Honor.
Did, Glory's the only one that filed to appear telephonically, the Korean. Okay.
But Molly said that her client's appearing telephonically too, and I said that's only.
Well, just bring in